Now, a lot of you have bought my book today. Thank you. I have more money, so I can get it printed. Woohoo! Took me 1.5 to 2 years to find all of that information. There's also, I have another small booklet out there for $10 on the patents. And the fun part about that $10 one is, in that document is a survey of I think it's a 1962 land patents, because they're still issuing patents. They're still granting land under the Public Lands Act today. So does that tell you they're not worth anything? Anyways, this guy got his letters patent from Queen Elizabeth, and in the survey, what is reserved? 815 feet up from the water's edge for flooding. Who lives in a floodplain? Only the guy that has it reserved in his letters patent. Think about it. If they had to reserve 817 feet to allow them to flood up to that 817 feet, if it's not reserved in your letters patent, who's telling you you have a floodplain? That third-party corporation called the Conservation Authority that has no jurisdiction over anyone else's private property but their own. Because if you read through the Act, and actually in the Conservation Authority report that's here, I think it was either in 1981 or 1985, they were going to allow the parks and the conservation authorities, and if you're wondering why I'm looking up, I'm actually quasi-reading it as I'm going. They were going to allow the conservation authorities and the parks to regulate drinking in the parks and on the conservation authorities' land during long weekends. And that was with the approval of the minister. What does Section 28 start off with? The conservation authorities may create regulation with the approval of the minister. Can the conservation authority tell you you can't drink on your private property? That's all they can regulate for, is the property that belongs to them. They were created originally under public works to ensure that there would be no flooding or erosion, and they were to actually go and walk through the water and pick up the garbage that was in the water. That was their job. They were created, the overall encompassing conservation authorities were created in 1946 because we had hundreds of thousands of people coming back from World War II. There had to be jobs for people. That's also the year the Planning Act was implemented. The Planning Act is not applicable to private property. All you have to do is actually read the legislation. No one is reading the legislation in its entirety to know and understand what it is actually saying. Lawyers do not have time. The Municipal Act is 387 pages long. That is just one part of the Municipal Act. You have the Municipal Franchise Act. You have the Municipal Elections Act. Then the municipalities have to be concerned with the building code, except for they don't, because it's only applicable to them. The building code now with regulation is 1,853 pages. The definition of an outdoor pool in the building code is a public pool that is not indoors. Why are you going to get a permit to put a private pool in your backyard? Because they told you you had to. Because they haven't read it either. Think about it. Not only that, there is like 80 different pieces of legislation our municipal councillors are to know and understand. That's just provincial. That's not including the regulations or the policies. Then you have the federal legislation, regulation, and policy. Then you have all of the constitutions, and I'm not talking just Trudeau's 1982 document. It includes, because actually, the Royal Proclamation of 1763 is actually part of Section 25 of Trudeau's document. So you have to know the Royal Proclamation of 1763. You have to know the Union Act of 1774. You have to know the Constitution of 1792. You have to know the Union Act of 1840. Then you come through to the British North America Act of 1867. You have to know all of these things if you are an elected official, even at the municipal level. Then they're to know all of the bylaws that have ever been passed, and they are to keep up to date on all current court cases. That's why very few people know about the Moyer case and George and Bluff, and how bylaw inspectors are to know and understand the limitations of their legal authority. And the township had trespassed because they did not like the way Jim Moyer created his privacy fence around his junky yard, because he happened to think that stacking skids was creative. Isn't that innovative? Because they went to Jim and they said, Jim, you got all of these old buses and old cars on your yard. We want them removed. Jim says, I don't have to. They're mine. Well, then you got to put up a fence. So Jim went around to all the different businesses and he got all their spare skids and he stacked them up. He's also very thrifty. He must be Scottish. Anyways, I guess bylaw felt a little affronted at Jim doing this. So not only did they take down his beautiful fence, they also carted away some of his stuff to the wrecking yard. Jim sued the municipality. The first court case said that all they would do was remove the charges, because they were going to charge him for cleaning up his yard on his property taxes, and that they would give him a little bit of money towards the vehicles that were taken to the wrecking yard. That wasn't good enough for Jim. He appealed the ruling. So not only did Jim get it removed off his property taxes, he also ended up with between $70,000 and $90,000. And that's because Jim stood up for his rights. So, yay Jim. Everybody thought he was crazy. Can't fight City Hall. I've heard that time and time and time again. You can't fight City Hall. I fight City Hall every frickin' day. And you want to know why I became a landowner? I'm going to tell you why I became a landowner. This is funny. You remember in 2005 when everybody's assessments went nuts? So I took on MPAC, and I got the Ombudsman's report. Now, we have less than 1 acre, and we have 1,000 square feet. And our new assessment was supposed to be something like $383,000. I don't live in the butthole of the world, but I can see it from where I live. So you can imagine, because our previous assessment was only $197,000. So I got a little nasty with MPAC. By the time I was finished, it was down to $237,000. But I was not the only person. Now, my father was sick and my mom was sick at the same time. But my dad's friend's assessment went up 100%, and so did all of his neighbors. And so he asked me if I could help his friend. So I did. I wrote a form letter. And so his name is Jim Turner, and he used to be with Dufferin Landowners. He's not well. He took that letter to all of his neighbors. All of their assessments went back to exactly what they were before. And then he asked me if I would please become a member of the Landowners Association. At the same time, I was trying to get veterans benefits from my father and his medals, because he fought in World War II. So I got into the fray with Veterans Canada, and I ended up getting a call from Toronto from the head supervisor saying, Elizabeth, your father will be getting his veterans benefits because we've never had anybody go after them 6 different ways to Sunday. You're killing our staff. That's what it takes. So every day I read legislation. I have been told I have one of the largest libraries of statutes, pretty well North America or in the world. I have, are you ready? This is the name of this act. It is called An Act for Quieting the Subjects Against All Pretense of Concealment from 1769. And you're going, what the frick is that? That, ladies and gentlemen, is the Nullum Tempest Act of 1769, which limits the Crown to 60 years. It involves the letters patent. Once that 60 years is done, there is absolutely zero Crown authority. It also involves the 60-year adverse possession. If you want to check it out, get Holdcroft versus the Ministry of Natural Resources, 2004. That's when it was, that I know of, last used. The Nullum Tempest Act is also part of your rights because it did place the Crown on the same footing as the private property owner. And that was a document that I received from a lawyer in Nova Scotia. Because there's also the Brill case. There was 200 years possession from the Crown, and because of the fire in Halifax, Nova Scotia, equivalent of M&R, are trying to take back everyone's land because they don't have a copy of their letters patent. Would you like that to happen to you? So in 2010, this lawyer used the Nullum Tempest Act to uphold the 60 years. And in that document, he has gone and done the research, and actually his research led me to the book where it explains that this document, this act for quieting the subjects against all pretense of concealment, the Nullum Tempest Act, means that after 60 years, the Crown is you. And that's the way it works. So if the Crown had any want, need, or desire in your property, it had to happen in that first 60 years. And if you want real proof of it, go to section 3.1 of the Real Properties Limitations Act, which stands in this province today, and you will see the 60 years. Anyways, how many minutes? 8. Anybody got a question? You, I always get. No way. You sit down. Yes, you're new. He's new. You always stand up. Tall man, yellow coat.
The question is, well, I'd like to preface by sort of thanking you for your hard work and the knowledge.
They can't hear you with the mic down there. Hello?
I'd like to sort of preface it by thanking you for all the work and enthusiasm that you have in giving us this information. But
You don't get out much, do you?
the question is, that sort of my understanding that in court we rely on the sort of judicial system to both apply the law and interpret it.
Yes.
How, in your opinion, is this sort of letter patents being used by the judiciary?
This
Do
is
they
the thing.
understand it?
Actually, no. And actually, there was a fellow I was talking to earlier, and he actually used his letters patent a few years ago. And the judge actually, the case went on for 2 years because the judge had to research it. It was actually used in 2001, and that's Saker versus Middlesex. In Saker versus Middlesex, Saker had 8 acres of land, and he wanted to use the Beds of the Navigable Waterways Act because he had a creek going through it. Give him 5 acres on one side, 3 acres on the other side. Middlesex Center was the municipality, actually used Saker's patent against Saker because he owned the woods and the water, and so he couldn't use the Beds of the Navigable Waterways Act because it didn't apply to him. But this is the thing, some know, some don't know. In the Guide to the Federal Real Properties Act from 1985, it states that the letters patent must be kept for esoteric legal reasons. I interpret that statement as for the instructed and kept secret. To me, this is a denial of our rights to us. On top of that, I just recently found a report from 2004 done by the Treasurer of the Law Society of Upper Canada. Our lawyers are not being taught the law of equity, they are not being taught the law of evidence, and they are not being taught common law. The Treasurer of the Law Society of Upper Canada took on a dean from a prominent law school, and she said, "What are you doing about this?" And he said, "It is not our job to teach them the law, it is our job to teach them to be lawyers." It is our jobs to teach them the law, because if you do not know and understand the law, Section 19 of the Criminal Code of Canada, ignorance of the law is no excuse. So every time I sit down at my keyboard and I do up one of my big honkin' reports, that's me taking the legislation and putting it in terms so that everybody can read it, so that you all can know the law and you can start standing up for your rights.